I need to let you know, everybody, that you're now being recorded, but basically Janie's being recorded. I think we're ready to start back up again.
Okay.
I would like to introduce all of you to Jane Jarrow. She is graciously sharing her knowledge with us today, and we really appreciate that. So I'm going to stop talking, Janie, and give you time to talk. So here we go.
Okay. Now, can you all see me on the screen? Because all I can see is the black screen with Donna's name on it.
Yes.
Yeah.
Okay. All right. Okay. Good morning, everyone, and thank you for bringing me into the confines of your conference this morning. I have been doing the session that you're about to hear all over the country by Zoom or Teams or whatever. You are like the 14th or 15th state group that I've talked to. This is my pro bono work for the spring. I am trying to provide information for folks about ESA documentation, and I'm hoping to provide it in time for you to still use it for the coming school year, and then to think about using it beyond.
This is good.
Is that?
We're good.
Okay.
Yep.
Donna, were you able to share with everybody the documents that I sent?
We're in the process of doing that.
Okay. And you don't have to have those in front of you to follow what I'm saying. I just want you to have them for later on as far as that's concerned. And so I've sent them electronically so that Donna can forward them on to you and you'll have them when you get home or whatever. But the bottom line is that we have been doing, we've been trying for a very long time to get a handle on this ESA thing. And everything we've tried to date is not working. Since 2015, I've been putting out something that many of you have seen called the ESA watch list, where we put together a list of names of the people writing the less than legitimate letters in support of ESAs and said, if the name is on this list, you have good reason to be concerned. If the name's not on the list, it doesn't mean that it's legitimate. It just means they haven't made the list yet. And it gave information about how to handle it and what you could say if there was a concern about the legitimacy of the letter. And it's gotten us nowhere. Number one, the names change faster than we can keep up with it. Number two, depending on where you were, the attorneys, when push came to shove at your institution, all too often people found the attorneys saying, are they legally licensed in this state? Then you have to take what they say, even though they agreed with you that it was a fake and that they didn't have the information that they needed in order to make the statements that they were making. It didn't matter. If they were legally licensed, the powers that be weren't going to let us oppose it. And so the whole thing's just kind of snowballed and gotten out of hand. Over Christmas break, I had one of those epiphanies where I had a better idea. And what I'm going to present to you this morning is what came out of that better idea. It is a suggestion for a different way to approach documentation for ESAs. I need to preface this remarks, and in the longer of the two documents that I sent, you're going to see a lot of the stuff we're going to talk through today. But there's a discussion in there that says, if the reason you are looking to adopt this is because you think it will get rid of more ESAs, that's the wrong reason to be using it. I came through school at a point in time long before we ever thought about having animals in the residence hall. But then again, we didn't think about having students with significant mental health issues in the residence hall. Most of you came through school long before there were animals in the dorm. It doesn't matter what we were used to. At this point in time, not only does the federal law say that we need to look at this as a viable alternative, but we've got current students, for whom having an ESA makes a significant difference. And I don't want to downplay the legitimacy or appropriateness of an ESA for a student who really needs an ESA. I'd just like to see us get a better handle on those who don't need an ESA, but think it'd be really nice to have FIDO with them. And so the purpose of this is to try and get a better handle on sorting out the students who really need the ESAs from those who don't. I'm going to walk you through the form that you will see that gives suggestions for a new way of gathering information regarding the need for an ESA. And I need to keep reminding you that these are suggestions and that there will be some questions on that form that you're not comfortable with, or there'll be some questions on the form that the powers that be, if you float it past them, will say, no, you can't ask that. We don't want you to ask that. It doesn't matter. You don't have to adopt the form in total. You don't have to adopt it at all, obviously, but you can pull questions from it and add it to what you're currently doing, or you can use most of this and change things up as you see fit. There's no obligation on your part to buy what I have to sell. It's just that I'm going to try and explain to you why I set it up this way and hope that I can convince you that some of this has utility for your purposes. I should have prefaced this by saying, since I can't see you as an audience, I don't know when you have questions. So I will pause periodically and ask if there are any questions, and somebody there will have to let me know. But if somebody has a question and I haven't stopped talking, Donna, interrupt me. Somebody interrupt me. Okay. All right. Very good. Thank you. Okay. Just as a preface then, following the path that I'm going to suggest to you in this packet is not for the faint of heart. If your administration or legal counsel asks, how do we know that the student won't file a complaint if we do this? The answer is, you don't know that. And if that's what worries them most, then you should just accept the documentation that's provided and move on. If your administration or legal counsel ask, where does it say that we can ask these questions in this way? You'll find some of the answers you need in the line-by-line reviews suggested in the documentation that I gave you. I've explained both why the statements are included and why they're phrased as they are. Whenever possible, I've tied those explanations to specific language used either in the HUD guidance or the UN Kearney settlement agreement, and we'll talk about that some more. If your administration or legal counsel ask, on what basis are you rejecting the paperwork presented by a licensed professional, remind them that you're not rejecting their paperwork. You're simply saying you cannot fully evaluate the request until you have all the answers to the questions you've asked. If the paperwork presented doesn't give you all those answers, you'll need additional information. In other words, we're going to stop saying we can't accept this documentation because of where it came from. We're going to say, thank you for this documentation. Now we need more. If your administration or legal counsel don't want to take any chances, then don't do it. You can't get in trouble from a legal perspective from saying yes, no matter how ridiculous the claim. There's nothing to be ashamed of if the institution chooses to take the path of least resistance and tells you to just say yes. Rather, it's very brave of the institution to be willing to say no, to say stop. Are we clear on that much?
Yeah.
Okay.
Yes.
All right. I don't think anyone would argue that the issues of ESAs on campus have become more than a little overwhelming for most of us over time. We've spent almost a decade trying to find a way to assure that ESAs are available for students who really need them while staving off the onslaught of requests for ESAs from students whose documentation in support of their request doesn't clearly establish the need. The HUD guidance repeatedly references the idea that we have a right to make decisions based on reliable information submitted with the request. We've spent a decade or more insisting that the letters for hire aren't reliable because they don't come from a reliable source. The letter writers don't have adequate knowledge of their clients, and that approach isn't getting us anywhere. It's time we started focusing on whether we're looking at reliable information, which is what the HUD guidance talks about, reliable information. Is there enough information and detail presented to allow us to make an informed decision about the request? If all we're given is a vague statement of diagnosis and an even more vague suggestion that the ESA will fulfill a useful purpose, coupled with a very direct threat of legal action if we don't do what we're asked, we should be in a position to say, I don't have enough information to consider this request. When I have the answers to all the questions asked, I'll be happy to talk with you about the accommodation. We don't need to reject either the letter or the letter writer. We simply say, that's a start, but I need more. I'm going to, again, go through the request for documentation form, but I need to preface that review by reminding you that we ask for documentation of disability in our field for two reasons. The first reason is to establish that this is a person with a disability, therefore protected under the law. And the second reason is to establish what, if any, accommodation is necessary in order for the individual to have equal access. In this case, full use or benefit, or full use or enjoyment to the facility. But that two-pronged purpose of documentation has always been in place. We've been doing it with everything else for ages. When was the last time that you got a letter from somebody saying this student is LD and will need accommodations, where you stopped there? No, you want to know how their learning disability impacts on them before you determine what accommodations are necessary. For whatever reason, over time, we got hung up with ESAs on that first purpose of documentation. We kept looking at whether they were really a person with a disability, whether the documentation really established that they were a person with a disability entitled to accommodation. And if they were, then we accepted the second part, that they were going to get the ESA, and this was the ESA that they were going to have, or we dealt with that separately. But in fact, it's two separate steps. Is this a person with a disability? What, if anything, do they need for accommodation? We need to go back to that with ESAs. The letter that we're getting from the professional or not so professional that says this is a person with a disability, that fulfills the first purpose, but not the second. And we have the right. In the larger document that I'm sending you, on page 6, and you may want to make a note of that, there is a quote that is terribly important and that you may want to highlight for yourself when you sit down to talk about all of this with administrators. It says, note, at some point, either the letter writers or the college attorney may point to the reference in the HUD guidance that indicates that for purposes of supporting a request for an ESA, documentation of disability may be provided by a letter from the individual's healthcare professional. That's all it says. And that's true. That is what it says. But the guidance goes on to state, once a housing provider has established that a person meets the Act's definition of disability, the provider's request for documentation should seek only the information that's necessary to evaluate if the reasonable accommodation is needed because of a disability. We're accepting the letters for hire as establishing that this is a person with a disability. Now we're asking for further information necessary to evaluate if an accommodation is needed. The information in the new form is specifically targeted to the question for the need of an ESA. It matches that guidance. In other words, the guidance has always said the guidance says we have to accept the letter from a licensed professional that says this is a person with a disability. And that's the part we've been fighting. We're not going to fight that anymore. We're going to say, and now tell us why we need to give them an ESA. That's a separate piece. It's hoped that this new approach will be seen as appropriate and allowable by the attorneys. We're not refusing information or a diagnosis that comes from a licensed professional. We're simply saying we need more. Okay, any questions about that much?
People are looking like they're contemplating.
Okay, very good. Before I start in on the form, there is a step 2 of this new documentation process that I'm going to suggest to you. And again, it's one of those, well, of course things, but it isn't something that we've been doing a lot. The second step in this newly proposed format for gathering information, it seems ironic that since 2012, I think, is when WINAHEAD came out with their revised guidance. We've been focusing on student self-report, and we've been saying, first step, not the only step, but the first step is to sit down and talk with the student. But we haven't been doing that much with ESAs. We typically have talked with the student about where their documentation came from, but we haven't included a significant interview with the student as part of the documentation process. And I would suggest that it's time we started doing that more often. We are dealing with these bogus letter writers all too often who are practiced and rehearsed at how to respond to our objections to how long they've been seeing the individual or what they can say that with language that skirts the need but can't be questioned, etc. They're very well rehearsed in terms of the way they respond. I guarantee you the students are not that well rehearsed. They are not going to have pat answers ready for the questions that you can and should be asking about why they want an ESA. And on page 7 of the document that I sent, there are some suggested questions that you might ask in an interview with a student about their reason for wanting an ESA. What's your understanding of the purpose of an ESA? Why are you asking for an ESA at this time? How do you think having an ESA will help you in dealing with your mental health concerns? Let me just say those 3 things, while they are things that may make it clear to you that the student really doesn't have a need for an ESA, they just thought it would be neat to have Fido there with them, or the kid next door to them has an ESA and they thought they'd like to have their pet there too. Those kinds of questions asked, how do you think this will help with dealing with your mental health concern? Why are you asking at this time? Those are all good questions for sorting out those things. They are also good questions for giving you information that says, I don't care where this documentation came from. This is a kid who could really use an ESA. Somebody I did this presentation for early on sent me some information that had been returned to them in response to an interview that they did with a student. And they asked the question and they said, why are you asking for an ESA at this time? And the reason they asked specifically was because the student was requesting the ESA in late February. And they have a rule that says, except under unusual circumstances, we don't accept ESAs. We won't approve ESAs during the middle of a semester. And the student had come to them with an emergency request to get her ESA. And they said, why are you asking for the ESA at this time? And she said, I am barely hanging on here. I barely hung on during the fall semester. I had all sorts of problems. And I was a nervous wreck at the end of fall semester, but I went home over Christmas break and I had the dog there with me then, and it made a significant difference. And I came back feeling much better, and I can feel myself starting to slip again. I've been doing this, this, and this. I'm really scared that if I don't have, that maybe the dog will help me make it through the semester. This was a kid who was falling apart at the seams, and they approved the dog, but they approved it because they talked to the student about why and didn't just go by rules. So these questions help on both ends. Dogs and cats are not the only ESAs that we accept at the institution, but they're the most frequently requested. What animal are you requesting? As noted in our policy, your ESA must be caged or crated when you're not in your room. Are you concerned at all about leaving your ESA alone in a crate for long periods of time? There's a series of questions there that you can ask. You may have your own questions that you want to add in, but I would encourage you to start including a conversation with the student who is requesting an ESA, in addition to whatever formal documentation you get from an outside professional. Any questions about that?
Anybody have any? They're with you. They're hanging on.
Okay, then let's talk about the form. Now, did you pass out a copy of the form, Donna?
No.
Okay, all right, that's fine.
I emailed it to them.
Okay, that's fine.
Oh,
that's
can you
fine.
forward it to everybody who's. I didn't. We're getting it.
The email
Okay,
was
that's-
sent out to everyone. Yeah. it
Okay.
was.
Okay, that's fine. I'm going to go through the form with you line by line. And when you get back and open up your email, you'll have it there and you'll see what I've talked about. And this line by line review is in the longer of the 2 documents I sent. So you'll have everything you need there.
They also have it in front of them now, Janie, on their email.
Oh,
They
okay,
have it.
very good.
They have it.
Okay. The request for information
The
regarding
request
emotional.
for information.
Yeah. You want to open up that request for information regarding emotional support animal, the new form, and have the form in front of you if you have the availability. And again, if you don't, it's okay, because I'm going to talk it through. On the top of the form, there is a box that says note. ESAs may not be brought into the residence hall until official approval has been given from the Office for Disability Services. Please submit all necessary information with enough lead time to allow the office to fully consider your request. That statement that says you can't bring the animal in until after you've gotten formal approval probably appears several other places in the on your website and in that information you send out, etc. You're putting it up here because you want to make it very clear, should the question arise later, that there's no way they didn't know that they weren't supposed to bring the animal in until it had been officially approved, that they were told that at frequent intervals along the line. No matter what their first point of contact with the rules, they will have seen that message. Then it's got the title and it says, the healthcare provider need not use this specific form, but all the information requested here is necessary for the institution to have in order to consider the request for an ESA. The form is provided as a convenience. Now, let me talk real quick about the HUD guidance. When I say HUD guidance, I'm talking about the HUD guidance from January of 2020, which is the most recent and the ones we're using at the moment. The HUD guidance is guidance. It is not statute. It is not law. There are two or three places within that long HUD guidance document that says, these are not rules. This is guidance. You are not legally required to follow what it says here. You are not in non-compliance if you don't follow what it says here. So we don't legally have to follow what it says in the HUD guidance from 2020. And there are a couple of places where I'm going to suggest that we not follow it. Having said that, if we can follow it, there's no reason why we shouldn't. There's no reason not to show that we're aware of the guidelines and the rules that they set and that we are honoring those as much as possible. And that HUD guidance says that you shouldn't ask them to use a specific form, but that you can provide one. So that's exactly what we're going to say here. The healthcare provider doesn't have to use this form, but we need all of this information. So you can use the form or you can give us the information in another way. The important part there is all the information requested is necessary in order to not approve, in order to consider the request for an ESA. You won't consider the request until you get everything you asked for. Then it says, generally, we prefer documentation from providers in the state of, in your case, it would be Iowa or Nebraska or wherever you're at, or the student's home state, who have personal knowledge of the student consistent with their professional obligations. That's a holdover from the old form. In the early days, we used to be able to sort out some of the bogus letters when you had a student who was in Iowa who had a letter of documentation from a service provider in California, and the student themselves was from New Jersey. You know, if it was clear that they'd never been in the same room together, it was an easy way of saying, this won't work. In this day and age, number one, the sites have all gotten, the bogus websites have all gotten better at it. I just actually was on one of those sites a half an hour before we got on the phone because I was looking up something for somebody. And when you apply for a letter from the website, it asks you what state you're in, because they're going to send you to somebody who is licensed in your state, who is there, so that there isn't that geographic boundary that jumps out at you. Above and beyond that, since COVID, telehealth services are preferred in many cases and certainly accepted as viable. So it's not as good an indicator of real contact and real interaction with the individual, but it doesn't hurt to ask. Then there's a shaded box on the form that says, some websites sell certificates, registrations, and licensing documents for assistance animals to anyone who answers certain questions or participates in a short interview and pays a fee. Under the Fair Housing Act, a housing provider may request reliable documentation when an individual requesting a reasonable accommodation has a disability and disability-related need for an accommodation that are not obvious or otherwise known. In HUD's experience, such documentation from the internet is not by itself sufficient to reliably establish that an individual has a non-observable disability or disability-related need for an assistance animal. Excerpt from the 2020 HUD guidance. There's no question being asked there. They're not being asked to respond in any way. That's we know what's going on, and we're putting you on notice of the fact that we know what's going on. And we're making it clear to the student from the beginning that just paying your $89.99, which is what it was on the U.S. service animal site I just visited, is not generally not going to be enough. But it's there for informational purposes. It's not a question that they have to respond to. Okay, before we go into information about the student's disability, any questions about that first part? Okay.
Yes? Do
Eh,
you have a
oh.
question?
Okay.
Okay, we're good.
Okay. Information about the student's disability. Federal law defines a person with a disability as someone who has a physical or mental impairment that substantially limits one or more major life activities. That suggests that a diagnosis, label, does not necessarily equate with a disability, substantial limitation. What is the nature of the student's mental health impairment? That is, how is the student substantially limited? Okay, that's a lot of legalese that should look familiar to most of us, but there's some tricky things in there. First, the question always comes up, can you ask them about their disability? Can you ask them for a diagnosis? Again, this is one of those things in the 2020 HUD guidance where it says you should not be asking them for a diagnosis. Now, keep in mind that the HUD guidance is written for landlords who own apartment buildings and complexes and high rises and condo associations, and they have no business delving into the psychological problems or mental health issues for their residents. It's none of their business. So they've said, you can't ask for a diagnosis. We're in a very different position, and we have traditionally asked for that in other contexts for very legitimate reasons. But they have said you should not ask for a diagnosis because they're writing for the majority of the people who are going to be covered under these rules. We are not obligated to do what the HUD guidance says, and we have reasons for asking for more because we have more of an understanding of how to manage that information. But if we don't need to ask for it, why ask for it? And let's be real. When you get that letter that says this individual has anxiety and depression is defined in the DSM-5 and gives you the code number for the insurance coverage for it, that doesn't tell you squat about whether or not the individual needs an ESA. It doesn't tell you anything about the impact of the ESA or of the mental health disability on the individual. So we're not going to ask for a diagnosis. They want to give it to us, fine. But we don't want the label. We want to know the nature of the student's mental health impairment. That is, how is the student substantially limited? Now, there is also something sneaky in there. It says the nature of the student's mental health impairment. For reasons I have never figured out, in the 2020 HUD guidance, HUD removed reference to ESAs being for individuals with mental health impairments. They have opened the door for ESAs for people with any kind of disability. We're not going to acknowledge that. We're not going to accept that. We're not going to take ESAs for the kid who's blind because it'd really help him if he had an ESA there, because there's no therapeutic benefit. The 2020 HUD guidance talks about therapeutic benefit, but it doesn't talk about mental health impairment. Okay. The 2013 guidance from HUD, which was what was in place until the 2020 HUD guidance came about, very clearly ties ESAs to individuals with mental health impairments. We're going to continue to use the guidance from 2013 as it relates to ESAs at the college level. And so we have just very casually stuck in, we want to know the nature of the student's mental health impairment. Assumption being you're asking for this because of a mental health impairment. And I guarantee you, by the way, that if you run all of this by your counsel or your administration, they're not going to realize that we added something in here because they assume ESAs are for mental health impairments too. You might not point out to them that they took it out in the HUD guidance, but you and I will know that. Okay. Documentation of disability must come from a source with sufficient direct personal knowledge of the individual to clarify the need for the ESA and the nexus between the disability and the presence of the animal in housing. When did you first meet with the student regarding this mental health diagnosis? Again, stuck in mental health. What is the nature of your meetings? That is, face-to-face meetings or virtual interaction. When did you last interact with the student regarding this mental health diagnosis? How often have you seen this student or plan to see this student for further counseling or treatment? Those are all objective questions. You are not questioning the legitimacy of what they've said or anything else. You're just asking for straight information. What you're looking for is an indication that the student has a legitimate working relationship with the provider and that the provider has enough working knowledge of the student's situation to produce reliable information about the student's disability and need for an ESA. Asking for the date of the first meeting and the last meeting and the most recent interaction separately may help to ferret out those who've had one-time interaction for purposes of getting a letter. Even if the student contracts for additional sessions, if the letter is dated the day of the first contact, it tells you something. The question about face-to-face or virtual interaction is another hint as to the nature of their interaction and how well they know each other. Now, as we go through this form, keep in mind that there is no one question or two questions on this form where if they answer a certain way, you're done, you're not going to accept this. We're not going to deal with that anymore. We're going to look at the totality of the information provided. But if, when they answer those first four questions, you find out that they have been in contact virtually one time on the day that they wrote the letter, it does say something to you about the likely knowledge that the individual has about impact, or whether they're basically dealing with student self-report in and of itself, which is not the same in terms of being able to establish the relative need. What specific symptoms is this student experiencing, and how will those symptoms be mitigated by the presence of an ESA? General assessments are typically insufficient. For example, a statement that the animal alleviates anxiety is too general and does not explain how the animal may alleviate the symptoms of the student's disability. Was there a question?
No.
Oh, okay. Something interesting about that piece where it says, what are the specific symptoms, what specific symptoms is the student experiencing, and how will those symptoms be mitigated by the presence of an ESA? Again, we're looking for reliable information, depth of information about the student's needs. For the bogus letter writers, think about what you know about how those bogus letters come about. The student has that one-time interview with the bogus letter writer, if they have an interview. Sometimes it's just done by a form that they fill out online that tells what problems they're having along the line. And then the diagnostician says, yep, sure enough, you've got anxiety and depression, and I'll write the letter to that effect. In asking this question at this point in time, you are asking a question about specific symptoms that they're experiencing that will be mitigated by the presence of the ESA. There's a good chance that in those bogus interviews, they didn't ask that question up front, which means they're going to have to come back to the student to get more information, which is not likely to happen unless the student's going to pay more money to go with it. In other words, I would guess, I don't know this for sure, but I would guess that most of the time those interviews are done before they've looked at the form the student is going to have them fill out, or they're done with the idea that they're going to send their boilerplate language letter. And by asking for more in-depth information, we may be able to cut down on some of the less than satisfactory submissions because it doesn't include all the information that we legitimately had a right to ask for. Information about the proposed ESA. And then it says, note, there are some restrictions on the kind of animal that can be approved for the residence hall. It is possible the student may be approved for an ESA based on the information you provide here, but may not be allowed to bring the specific animal named. Okay, again, another place where we have gotten into really bad habits when it comes to ESAs. We have spent a decade arguing about whether they really have the right to tell us that this is a person with a disability who needs an ESA. And then we have largely accepted whatever animal they've said, you know, if it's a really weird kind of thing, we've questioned it. But if it's a dog, or a cat or a bird or a hamster or whatever, we've asked them on the bottom of the form, what animal are we talking about here? And we accepted that if we accepted what was at the top of the form, that this was a person with a disability, that we were accepting the animal that they proposed as well, that animal was part of the prescription. Nobody has the right to tell the institution how it will accommodate a student with a disability. The outside provider may be in a position to tell you this is a person with a disability who is entitled to non-discrimination. But nobody outside the institution tells you what the institution has to do to make that happen. When you get a letter about an LD student that says this student is learning disabled, and it follows up by saying they don't do well under stress, and therefore they should be given triple time on all tests, are you going to do that? No, you're not. You're going to say, that's not an appropriate accommodation. That's not something we do at this point in time. We will provide extended time in X amount. If you got a letter from somebody for a student with a psych disability that said the student doesn't perform well under tests, they shouldn't be asked to take any tests, would you do that? No. You would accept that this is a person with a disability, but you're going to decide how that student will be accommodated at your institution. That's all we're doing here. We're saying we're going to accept from you that this is a person with a disability, but how we accommodate them is up to us. So you can make a recommendation about what animal it's going to be, but we'll decide whether that's appropriate or not. There's two separate decisions to be made there. Okay. The name of the animal, it asks for the name of the animal, the type of animal, the age of the animal, and the size of the cage or crate needed for containment. There are two sneaky things in those four very objective questions that are being asked. It asks for the age of the animal. It asks it in a non-confrontive way. It asks it just as a matter of fact in terms of identifying the animal along the line. You and I know that there are issues regarding age of animal that sometimes that are sometimes the reason for saying you can have an ESA, but not this ESA. But we're asking for it in passing as information that may be useful, that we need to have about the proposal. It's a good thing to have that information. We can come back to that in just a minute. And then it says the size of the cage or crate needed for containment. Again, this is it's sneaky. I was trying to think if there was another word to say, but basically it's sneaky. You are making the assumption, you are making it clear that there will be a cage or a crate needed for containment. I hope, all have that in your ESA contracts, that the animal must be caged or crated. But you are making it clear here on this form that there must be a cage or crate, and you just need to know how big it is. You're asking for the size of the cage or crate for a reason, but more importantly, you're making it clear that the animal must be caged or crated. Okay, before we go on to the next piece, let's talk about the age of the animal. One of two questions I get asked most often about ESAs is, can we restrict the age of the animal? Can we say no puppies in the residence hall? The answer is, yeah, you can. And invariably, somebody says, where in the HUD guidance does it say that we can say no to an animal because it's too young? And the answer is, it doesn't. The better question is, where in the HUD guidance does it say you can't refuse an animal because it's too young? And the answer is, it doesn't. HUD is silent on the issue of the age of the animal, but it does tell us that we get to we know that we're in a position to make decisions about what is allowed and what isn't. If you have rules in your residence hall that say you can't bring in an electric blanket, or you can't have your own microwave, or you can't smoke pot in the dorm, or whatever other rules you make regarding the residence hall, this is a rule that you're making. You can't have an animal under the age of whatever a dog under the age of whatever. because it's not conducive to being in the college setting, because puppies teeth and puppies wet on things and puppies bark and puppies whine when you leave them alone in a cage for a long period of time. It's disruptive of the educational setting. So you have made a rule that under general circumstances, there's always those weasel words in there. Under general circumstances, you will, a dog must be X old before you will allow it to enter, to be in residence in the dorm. Now, I hope you would also use that with some discretion. If the animal is 11 months old in August when it's move-in time, and it's going to be 12 months old next month, I wouldn't tell them that they couldn't bring that dog at that point in time. But if the dog is, if your rule is that the dog has to be a year old and the dog is 9 months old at the point where they want to bring it in, even though it will age out during the time you're there, 9 months is not a year, isn't even close to a year. And the reason you set it for a year is a reason in terms of how prepared the dog is for a communal living situation. Can you set an age limit on an animal? Yeah, you can. Why? Because HUD doesn't say anything that says that you can't. And this is a rule that you're making. Okay, let me stop there. Anybody want to ask questions about that piece particularly?
Yes,
Okay.
Hey, this is Debbie from.
a little bit louder. Can you hear her?
Yes, I can.
Okay,
So there's nowhere on here about vaccinations or licensing. The
Okay.
animal, not of the provider.
Okay. Those questions about health-related issues, vaccinations and licensing and that kind of thing, those generally go into the contract that you have regarding ESAs before the animal can be brought into the residence hall, the pieces that you go over about rules for the ESA. This form we're looking at is specifically what goes to the diagnostician who is providing documentation of the need for an ESA. So yes, there definitely should be rules regarding health certifications and that kind of thing, but they don't go in here.
So the medical or health provider, they'll know the animal, they should know the animal. They should know that information.
If they say that they don't, that tells you something too. Generally, if they say they need an ESA, but we haven't identified an ESA specifically, then my question would be, what if they've not had an ESA or an animal that they're attached to in the past? Why do you think this is going to be helpful at this point in time? Now, then they would have to give me a whole different set of justifications for why it is that they think an ESA is an appropriate support for the student if it's never been tried. I don't know that I've ever seen one where they didn't. I've seen requests for ESAs where they're planning to adopt one from the local shelter or whatever, if you approve it. And if that's the case, then yes, when they tell you how it's going to alleviate the symptoms, I'd want a whole lot more information supporting that need than just, we're hoping it'll help, fingers crossed. That doesn't suggest to me that this is a necessary request at this point in time. Usually it comes in with an animal named.
Okay, very good, thank you.
Okay, let's talk about the issue of the size of the cage or crate needed for containment. As opposed to the other things that I'm sorry, we've got that. I just make a note here that the UN Kearney settlement speaks specifically to one of the conditions that may mean one of the things that goes into your consideration of approving an animal is the size of the cage or crate. This is the one piece that very specifically comes out of the UN Kearney settlement and not out of the HUD guidance. Is everybody familiar with the UN Kearney? Do I need to explain that anymore?
not familiar.
Not familiar. Okay.
Correct.
The George Washington of ESA case law, if you will, the one that started it all for us, is a decision that came down for the University of Nebraska Kearney, which I'm pretty sure is in your federal district. I
Yep.
think, okay. So that makes it even more pertinent for your purposes, although the UN Kearney settlement is largely accepted as the prototype for people across the country. But it started back in 2009. It wasn't settled until 2015. But it was the first big case that said, yes, ESAs are approved under HUD's guidance for residence halls. It's the one that dealt with colleges and universities in a big way. And what is important in the UN Kearney settlement is not that they found that the university screwed up in not allowing the student to have their ESA, but this is one of those technical detail kinds of things. HUD is under the Housing and Urban Development. HUD is Housing and Urban Development. That branch of the federal government does not have lawyers. They have lawyers within them, but they don't do litigation. If there is a HUD complaint brought, it is litigated by the Department of Justice. Now, we know that the ADA is under the Department of Justice and that those people know a whole lot about disability that the people in HUD don't. This case went to court, and because it went to court, it was litigated it didn't go to court. It went into settlement agreement. It was litigated by attorneys from the Department of Justice. And the settlement agreement reflects the Department of Justice's thinking about ESAs more than it does HUD's, but it is the accepted prototype for what we do. And what's important in the UN Kearney settlement is the policies that were vetted at the end of that settlement. In the settlement agreement, it shows the policies for housing accommodations and for ESAs that the Department of Justice approved could be used by UN Kearney in settling this complaint. And a lot of things in that settlement are things that you see now regularly appearing in our contracts, which they should. The UN Kearney settlement doesn't tell us everything we need now, 9 years later, but everything that is in there is something that probably ought to be in your contract. And this issue of the size of the cage or crate needed for consideration is from the UN Kearney agreement. If there are folks who've never seen it or don't know much about the UN Kearney settlement who would like to have a copy of it, if you will write to me at Jane Jarrow, JaneJarrow at AOL.com, I will be happy to send you a copy of the settlement agreement. I have it on my system. We okay?
Yes.
Okay. Going back to the form. Dogs and cats are most often requested as ESAs and seem best suited to adapting to the communal living setting of the college residence hall. If another type of animal is being suggested for the student, please explain why you believe that animal is a better choice. The reference to dogs and cats being most often requested is true. It doesn't say you're restricting ESAs to dogs and cats, but it suggests that they're more easily acclimated to life in the residence hall and potentially more likely to be approved. It's easier for the institution to establish rules and assess appropriate behavior for dogs and cats than for other species. Why not subtly encourage their selection? If you can get away from the weird types of animals and having to deal with that as part of the ESA decision, it makes your life that much easier. So if we can get them to stick to dogs and cats, let's push them in that direction. Is there evidence that an ESA has helped the student in the past or currently? If not, why do you believe this may be an effective support for the student now? This goes back to the question that was asked about what if they haven't got an animal to be named? This is where I would want to see something pretty significant if they're recommending this without it ever having been tried. If the answer is the student is having trouble and they think maybe having an animal there would help, I'm going to be very hesitant to say, let's go ahead and approve this when it might help, but it might not help. This is not significant information as far as I'm concerned. Then it says, please address the likely, okay, this is one of those tricky questions that some folks may not want to go with. I like it. I actually adopted this from somebody else's form. Please address the likely impact on the student should the following scenario occur. Once the student is living with the animal in the student housing unit, the animal is permanently removed from the unit because of violation of policy. For example, the animal injures someone or destroys property. And balance this impact, if any, against the benefit that you expect the animal to provide the student. We're saying, what if we allow the student to bring the animal in and then it has to be removed later? Is that going to be a problem for them? I can't imagine a circumstance in which they'd be putting together this documentation where they're going to say, oh, gee, yeah, that'd be a real problem. So no, maybe we better not let them in. Let them bring it now. They're going to say, nope, no problem whatsoever, especially because the examples you've given are the animal injures someone or destroys property, and the student will assure them that that's not going to happen. So it's okay if they say, no, it's not a problem. Let them bring it. If it's got to be gone later, it's got to be gone later. You and I know that there are a whole lot of other reasons in terms of violation of contract agreements and policies where you may get to a point where you say, sorry, the ESA has got to go. What we often have when it comes to that is the student saying, but I can't manage without my ESA. I've got to have the ESA, and you can't take this away from me. And it makes other people hesitant in conduct proceedings, et cetera, to say, remove the ESA when you've let them have it there because presumably they needed it. By putting in this question and having the diagnostician say, if it has to be removed, so be it, you are in a better position to take action if it's needed, for what it's worth. Okay. Then there are two statements that are really there for information purposes. It says the student was provided with a copy of the rules and restrictions surrounding the presence of an animal in residence in university housing. Has the student shared those restrictions with you? Yes or no? Have you discussed the responsibilities associated with properly? Question?
You just cut out for just a second. So could you go back to copy of the rules?
Okay. This student was provided with a copy of the rules and restrictions surrounding the presence of an animal in residence in the university housing. Has the student shared those restrictions with you? Yes or no? And then it says, have you discussed the responsibilities associated with properly caring for an animal while engaged in typical college activities and residing in campus housing? Do you believe those responsibilities might exacerbate the student's symptoms in any way? If you've not had this conversation with the student, we'll discuss it with the student at a later date. These two questions are not really meant for are really meant more for the professional providing the documentation than for information purposes. Too often, legitimate healthcare professionals are coaxed into providing ESA documentation for a patient because the parents convince them that the student would really like to have their pet, and hey, it's no big deal. Everyone has animals these days, right? These two questions are a reminder to the provider that it is a big deal. That's what they're there for. Then it says there's a standard sign-off form. Please provide contact information, sign and date this questionnaire below, and return it to the institutional contact named. Address, telephone number, fax, professional signature, type of license, license number, date. It's fairly standard information. And then there's a sign-off form. It says, student, please sign this form before providing it to your mental health provider to complete. By signing below, I consent to allowing my healthcare provider to share any information relevant to my need for an ESA as an accommodation, as shown on this form, with personnel from the DSS office for the next 60 days. Signature and date. That form is worded that way, or that statement is worded that way very carefully. It says, I consent to allowing my healthcare provider to share any information relevant to my need for an ESA, just about that. You're not asking for general information about their disability. You're not asking, this is not a fishing expedition. You're giving them permission to ask about your need for an ESA, embellishing on the questions that are shown on this form. So they're not adding other questions along the way. And only for the next 60 days. Why 60 days? Because you don't want it to be a blanket. You can have all the information you want. 60 days should be enough for you to be able to evaluate whether or not the student has a need for an ESA. And at that point in time, you don't have the legal right to go back to the service provider. Part of the reason that we do this is because a lot of the bogus mental health providers tell you up front that the information they have about the student is protected by HIPAA and you're not allowed to ask them any questions. Okay, that's wrong to start with. You are allowed to ask questions, but without going into the legal morass as far as why you're allowed to ask questions in spite of what they tell you. By signing this part of the form, by giving you permission, the student giving you permission, they can't pull the HIPAA crap on you and say, you're not allowed to ask those questions. The answer is the student has given you permission to get that information from them. Sooner or later, you're going to hit the student who says, I'm not signing this form, and you can't make me sign it. You can't require me to give you access to my diagnostician. I won't sign this. To which your response is, you don't need to sign it. That's perfectly well. That's up to you. You're right. You don't have to sign the form. Please keep in mind that if we don't have all the information we need, we can't consider your request. And the only reason we ask for this sign off is so that we can be sure we have all the information. But if you don't want to sign it, we'll work on the basis of whatever information you've given us thus far. You're done. Again, we're not questioning what they did or what they have to tell us. We're saying we need more information. And if the student figures that by not signing the form, they're going to force you to use the information that you're given and stop there, the answer is they're right. It forces you to use the information that you've been given. And if it's not enough, the answer is going to be no. Okay, that's the form. That's the reasoning that goes behind it. There is another section to the longer document that I have sent you. At the end, it says basically the bad letter writers aren't going away. And so there is some more information in there about both how to recognize and what to do, what you may want to do when you get the bogus letters and how you can respond to them. And I'll let you look through all of that on your own. Before I throw it open for a couple more questions, we started a couple minutes late and I'm talking as fast as we can, but most of you know how to get in touch with me. I gave you the email address once before. Donna can give it to you again. It's just janejarrow@aol.com. If after you get home and you look this form over, you have questions, please don't hesitate to ask. My whole purpose in getting this out there to everybody was to make it as usable as possible, as quickly as possible. I will also tell you that I have classes that I do, online classes that some of you have taken before. Hopefully some of you will take more in the future. And Donna, as I'm thinking about it, I've got an orientation class for new service providers coming up for the summer. And then by the end of the week, I will also have the catalog of classes for the spring, or I'm sorry, for the fall, ready to go. I'm going to
share
send
that. Yep.
Yeah, I'm going to send both of those to Donna and she will send them out to all of you as well. And one other thing, Donna, you can tell them what the last word is. I'll cut off at this point.
Yep.
I have a Friday thought piece that you're welcome to sign up for if you want it, and she can tell you more about that. Any last questions before I leave you and get out of your way because you've got other things to do?
I have one.
Yes.
How do you feel about reviewers of ESA? So like you approve it for 1 year to live in the dorms, and then the next year when they're considering living in the dorms again, is a review necessary? What should that look like?
Okay, what about renewing every year? I would ask the students to renew the request. Whether or not you ask them to renew the documentation, I've seen it done both ways. I think that they need to clarify the need for the continuing need for an ESA, because while their mental health issues may not have gone away, they may have found that there were some issues regarding having the ESA or problems or whatever. I would just want them to step forward and say, yeah, I want the ESA again. The question of whether you make them bring updated documentation remains to be seen. Keep in mind that the bogus letter writers, they say that those letters are only good for a year and they require that they get redone. Why do they do that? Besides making more money? They do. They do that because traditionally, you know, when you're dealing with that blind student, the first time they bring you documentation, you have no reason to believe that the following year they're going to be less blind. They're not going to need at least the same accommodations that they need. If they want more accommodations, they're going to have to bring you additional documentation. But you don't, if it's a permanent disability, then you don't need to update documentation along the line. Almost by definition, mental health issues are not permanent disabilities in that way. They do get better. They do ebb and flow. And you may have a student who's worse next year, and you may have a student who's a whole lot better. So yeah, most of the time I see people asking for updated documentation. Now, it may not be as complete as the documentation the first time. It may be just a letter signed off from the same service provider saying, I've been in touch with them. I think the ESA is working and I think it should continue to be provided. In other words, you may have a different kind of approval process for a continuing student. But yeah, I'd want to see it regularly.
Thank you.
Thank you.
Other questions?
How do you feel about visiting ESA, student whose ESA didn't work well in the residence halls on a daily basis, and so now they just want to bring it on weekends and things like that?
Whoa, wait a minute. Visiting, I missed.
Our housing is allowing for a visiting ESA. It was an approved ESA, and the animal did not do well in the halls, and so the student took it home. And the housing department is allowing her to bring her ESA on weekends. I just learned.
I think the housing department are being stupid, but it's not your problem. You know, that has nothing to do with disability. That has to do with silliness. You know, if they want to allow it on weekends, that's up to them. I wouldn't get involved. I'd say that's up to housing.
Okay.
Other questions?
Would you say that, like in your general housing policies, you list the types of animals that would be acceptable for an ESA, along with, like, we were talking about things like microwaves and electric blankets and things like that? So as not to get, tarantulas and cobras and, non-fluffy animals.
I would refer you back to the 2020 HUD guidance. There is some fairly comfortable language in the 2020 HUD guidance that if you wanted to, you could adopt in the form that you're using or in someplace on your website or whatever. But it talks about animals that are commonly domesticated animals are generally acceptable. And it lists, it gives a list that includes rats, which I would take out, but that's up to me. But it talks about commonly domesticated animals. ESAs are generally commonly domesticated animals. And it says if you want to bring an exotic or wild species, you'd have to, the person wanting to bring it has to make a case for why it should be allowed. So you might want to use that, go back to the HUD guidance and take a look, but that commonly domesticated animals is an easy way to go. Okay.
Are any colleges saying that certain dorms are the ESA dorms or allowing only in certain dorms?
Not legally.
Okay.
There actually are some court cases and ESAs or OCR settlements that have to do with attempts to restrict animals to only certain residence halls. To do so would be essentially restricting a person with a disability in terms of their choice of housing. If they have the choice of housing, if everybody else is able to live in any residence hall on campus that they qualify for in terms of senior, junior, whatever, then a student with a disability should have the chance to live in any of those housing areas that they qualify for. And to say, but you can't because you've got an ESA, is discriminating against them because of their disability. So no, you can't limit it. Okay.
Other questions? Go ahead. we have another question? Okay, thank you, Jeannie.
Okay. Thank you very much for giving me your time this morning. And again, please don't hesitate to ask questions later, and I'll send the information about the classes back to Donna. And have a good summer, everybody. Maybe I'll see some of you in Baltimore for the EHEAD conference.
Okay, thank you.
Take care, everyone.